You're watching Newsfeed AM. Let's get into this conversation now. The High Court in Pretoria has dismissed an urgent application by the Road Accident Fund to prevent the Auditor General from disclosing a report on the fund's financial affairs to Parliament or indeed the public. The Road Accident Fund wanted to stop the report being published pending a review of the Auditor General's findings. Let's get more on this story, including other matters that are ongoing within the Accident Fund. And we speak now to the Road Accident Fund CEO, Mr. Collins Letsoalo. Mr. Letsoalo, thank you very much for making the time to come talk to us here. Can we first get an update from you as to the status of the court case that we understand is ongoing between yourselves as RAF and the Auditor General?
Good morning, Trolly, and good morning to the viewers out there. I've got a strict instruction from the lawyers that I must not discuss this matter, but safe to say, the board of the Road Accident Fund Accounting Authority has taken an unprecedented step of taking a matter between us and the Auditor General on review. This was after we had had various engagements with the AG and could not agree. The long and short of this is that there is an accounting policy that we adopted covering the year 2020-2021, which was a change in accounting policy. We followed the PFMA section 55.2, which requires that the accounting authority must assess and report fairly on the financials of an institution. That's what we did, read together with GRAP 3, which is generally recognized accounting principles, read together with the directive. Those two are the standard, and the directive are issued by the Accounting Standards Board. We followed that whole process until we could not agree with the AG, and that's why we are in court. Our court case has got a Part A and Part B. The Part A was interdicting them from issuing what is a report, which we think that is unfair on both how we proceeded to do our matters. The view was that this should be interdicted from being spread out there until the court can review and hear our matter and see whether it will be set aside or not. So it is only fair that the matter waits until the court finalizes, and then we can then move on that basis once the courts are finalized, and that's how it came. On Thursday, we had a ruling on the Part A, which is the interdict, which said we are not successful, but that we are appealing. So that's how far we are. That's all I can say, truly, unfortunately.
And unfortunately, I'm going to try and press you on that because, yes, you are appealing, but have you filed that appeal?
Yeah, our leave to appeal will be filed today. We have got 14 days to do that.
So it will be filed today. So in fairness, we can actually talk about it because it's not entirely in court, at least Part A.
Well, I mean, Part A would talk about the merits, at least from a prima facie point of view, whether you have got rights to protect and whether you have chances of success. And therefore, I am not at liberty to discuss that. I mean, if anyone wants to know, these are matters that are in the public domain, because once they are court papers, then it's clear. So South Africans can go and read for themselves what our issues are.
Precisely, and that's why you are partly here, to educate the public about what is going on. Can I just ask you this simple question? To your understanding, does the RAF that you lead have a liability of 300 billion rand or not?
Well, it's very clear in our papers. I'm not going to respond totally. I'm saying in line with what we have submitted and the accounting policy, we are differing with the way the liabilities are accounted for. All I can tell you is that you can go and read for yourself Section 21.2 of the RAF Act on who is responsible once RAF can't pay, and it will tell you a story. Your common law rights are restored, meaning you can sue the wrongdoer. So ultimately, it's up to you to determine whether we have that liability or not. I'm not going to discuss what is going to be discussed in court in this forum.
So I'm not going to push you further, at least on the 300 billion rand part, because according to the Auditor General, that liability stands, and that's what you are challenging.
No, we are not challenging that. What we are challenging in court is the way the Auditor General has arrived at their conclusion and whether we can apply certain standards or not. And that's what we are challenging in court. Okay. We are not even challenging, it could have came clearly and said 600 billion. It mattered not. I mean, I don't think that that's what the issue is. The issue is whether we can use a certain accounting policy to determine, to fairly represent our financials, and that's it. And who has got the powers to do that?
So let's talk about this new accounting policy that you have adopted within the RAF. Your understanding is that that is the policy that you are going with as an entity, particularly a public entity. Why do you feel so confident that this is the right route?
Because accounting is very simple, Chloe. It's not a difficult thing. You just look at the standards and you apply those standards. That's exactly what we did. And nothing turns on the fact that we applied a standard that we are allowed to apply in terms of GRAP 3. So that's
how do you respond? How do you respond to the regulator who seems to understand that this accounting policy that you have adopted as the Road Accident Fund is not permissible in the country to be used? So how are you comfortable using an accounting policy that the Accounting Standards Board says it is not to be used in the country?
I'm not discussing that totally. Or safe to say what we said in court, which is Regulation 11.3 of the regulations of the Accounting Standards Board will tell you how they regulate. It's very clear. So we are not going to go and rehash what we have said in our court papers. Or people can say what they want to say. They are entitled to their opinion. Yeah. Our issue is GRAP 3 is very clear whose judgment must be applied when it comes to that. 55.2 of the PFMA is clear about who must represent the financials of the enterprise that you are running. So it's very clear about who runs the entity. The accounting authority must do that. And we are following that according to the rules. We follow the rules to the letter.
Well, some say you're not following the rules, but let's move on. And so you stand by what you announced last year, that you had turned a corner as the RAF and therefore declaring a 3.2 billion rand surplus.
Yes, Polly, let's take out this fuss about the accounting policy, because people want to say we declared the surplus because of the accounting policy. The accounting policy speaks to the liability. We didn't talk about the liability when we were talking about those matters. It's a simple thing. At RAF, we used to have our assets attached every day. We no longer have that at RAF. At RAF,
but you have to go to court to try and prevent that from happening.
Yes.
So it's not as a result of your clean books or how you're running that entity.
It is how we're running the entity.
Properly.
It's how we're running the entity. Simply put, you had someone who was owed 2,500 days old debt. You had someone who was owed 30 days of debt. All we did was to say, it's unfair, mainly to the smaller law firms, that there is a thing called a fixed allocation, where every month the bigger law firms would then be given money to apply to the debt that they are owed. When a smaller law firm, because they can't attach, they can't do other things, they are smaller, will see when we get about 3 billion at the time, 3 billion a month, and then we will apply about 1.5 to 1.8 billion to these bigger law firms, and then the other ones will focus on crumbs. But remember, when you go and claim from us as a claimant, it doesn't matter whether it's Letsoalo Incorporated at the corner or some bigger law firm. You have got the same problems as anyone else. You want to claim from RAF for compensation. So we went in and we said everyone must come within 180 days, meaning the ones that had 30 days must grow their debt to about 180 days. Those ones will lower. At 180, we pay everybody. So that's what we did. So it's work that we did. That's the first part. The second part is you must then look at RAF was struggling to even pay salaries at times. We had liquidity issues. We have addressed those liquidity issues. We have come a long way in terms of also our medical tariffs. We were paying 5 times. We have now issued out medical tariffs that are aligning us to all the other medical aids in the whole country. To say if it's a hip replacement for this much, you must know upfront what RAF would pay for that. So there is a lot of things that we are doing. People are focusing on this accounting policy. For me, it's a thing that is important that we must address, but it does not talk to the day-to-day operations of the Road Accident Fund. It has been there for, I think this 300 billion people have been talking about since 2014, or it has been growing since 2014 exponentially. So for us, the most important thing is running RAF, making sure that RAF is sustainable going forward.
Let me ask you this final question, Mr. Letsoalo. My understanding is that you are going to have a stakeholder session. You're going to be addressing people basically about the work that you do as the RAF. Why should South Africans be confident that you are running an entity that has money that will be able to pay out funds when you are steadfast and you're going against a very Chapter 9 institution that is meant to keep public finances in check? Who do you think the public should believe between yourselves and the AG?
Both of us.
How so?
Let me explain. We are differing with the AG on the issue around the accounting policy, not on everything. I mean, we respect that office. That office is the most important office for us to be able to be accountable to South Africans about what we do. The fact that we differ with them does not mean we don't respect that office. We engage with that office. We continue to engage with that office even now. The matter is just on the interpretation of the accounting policy, and that's as simple as that. All the other matters of internal controls, all other matters of accountability in line with what needs to be happened in terms of the data.
And so what it means basically is that you are willing to take the word of a private auditing firm, PricewaterhouseCoopers, over the word and standards of the AG.
That's not true. The AG does not have any standards. The standards are released by the Accounting Standard Board. The AG are auditors. We apply those standards. We are responsible for policy at RAF. So we produce the accounting policy in line with those standards. So there is no issue there. I'm saying the difference is only on the interpretation on that, regarding that, and that's the only aspect. One minor thing. People are making it big. We continue to work with the AG to make sure that we run clean governance within RAF. And that has nothing to do with the accounting policy. There is a minor difference there. Why are you saying it's big, Colin?
So it's big because it is the difference between whether the 300 billion liability that you refuse to talk about exists within the RAF or does not. Am I completely wrong in this?
You are completely wrong. I've said to you, it's about the application of a standard. Once that standard is applied, whether this thing comes at 600 billion or whether it becomes zero, it's immaterial. The issue is whether the standard must be applied or not, and that's the difference that we are having with the AG. We respect that office. It continues to be an office that we work very closely with to ensure that South Africans get their value for money when it comes to the running of the RAF, and that we are doing everything in line with that, in line with governance. Every recommendation that the AG has done, even now, on any matter, we still continue to implement those things. So we respect that office.
You've answered my question. You've answered my question because you say whether that amount comes back as 300 billion or 600 billion or zero, What matters is whether or not this difference between yourselves and the AG will determine the health status of your finances.
No, it will determine whether, in terms of the accounting, we are correct in our interpretation or they are correct in the view that they hold. So there is no issue there, Claude. For me, I find it odd that people would just be fascinated by this big thing and they want to claim that, no, you know, RAF is doing all these things outside. I continue to say, we respect that office, we will work with that office, and where we differ, like now, we will continue to engage with them, and where we can't, of course, judicial review is the way we must go. It's unprecedented, but it's something that must be done.
Well, you may take it as a small issue, Mr. Letsoalo, but for public finances, we understand that you are the next biggest liability for public finances after ESCOM. So you can't say that that is small, if indeed the liability does exist.
Yeah, well, that is what is important. That is what is important.
What conversation in view.
No, but what is important is the fact that we as the RAF have looked at our financials, we have done things in line with what we need to be doing, and we keep on saying the only difference we have between us and the AG is the application of an accounting standard, and that's it. What it spills out at the end, for us, it's going to be, and that's the importance of it. You keep on saying we are the second biggest liability. We are saying, if we are, let's apply the standard and see. The AG differs with us, and that's nothing wrong with that. I mean, there are two the chartered accountants from both sides who differ on how to approach an accounting standards, and I don't think that that means that we undermine the office of the AG.
Collins Letsoalo, let's leave it there, sir. Thank you very much for your time.